you in this way, I'm going to hold you in contempt, and then you're going to keep saying the same thing, and it's going to hold you in contempt. That's what is going to happen, because I don't really understand what it is you are saying.
I'm just asking.
So in court, you're going to ask, can the Crown, and the judge is not even going to understand what you're asking him. He is not even going to entertain it. He's going to give you an opportunity, and then you're going to keep asking that question, and then he's going to warn you that it's of no relevance, and then you're going to keep continuing to do that, and then he's going to warn you again and say that you're being contempt, when what you're asking has no relevance.
All right, no, I was only asking. I didn't say that. I'm just asking you, Sam, a question.
I understand that, but we have been down this road so many times. It's a question I don't even understand what response you want.
No, I'm not.
But listen, the reality is, Toby. The reality is, you've asked this question. The reality is that the Crown Prosecution Service, okay, the police investigated it. They put it to the Crown Prosecution Service, who made the decision that there was enough evidence for you to be tried in relation to this. Now you're asking, can a lawbreaker be the law mate or whatever? And I'm trying to understand what relevance does that have to your trial? Okay. And you haven't said anything to me. All you keep saying is, "Well, I'm just asking." But what relevance does it have?
Well, no, it doesn't matter. You are not going to be representing me, Sam. Anyway, so it's not going to be. I'm just shooting the. Talking of evidence, Sam. Talking of evidence, Sam. Talking of evidence. Did you get the? Did you get that statement?
I've asked for it and I haven't had a response. I've asked for it and I haven't had a response.
That's the police report, isn't it? When the actual items actually reported stolen.
Yes.
So whether it's actually proved when I was actually in possession of it, whether it was actually stolen.
Yes.
Yeah.
Yes.
So they still haven't supplied that?
No.
How comes?
Well, I haven't got it yet, Toby. I've asked for it, so that could be a matter for trial. But this is what I'm saying.
Oh, right.
You won't let us help you, but you keep going, how far? Why don't you just let us help and work with us? You won't do it.
Sam, how about
Sam?
No, Sam. It's not. Sam, it's not that I'm refusing.
You are. It just baffles me. I just find it just amusing. I've never actually had a client like you. It's just baffling me. It's like we're trying to help.
I'll take that as a compliment.
You don't want to be helped, so it's fine.
Well, that's your opinion.
It's not a thing. It's a fact. If individuals who are doing it are trying to help, trying to assist you, and they're telling you exactly what will help in this trial, right? I've told you categorically, as Steve Sweeney said as well, all we have to simply do is show that you doing that was impulsive. We put that before a jury. Jury is satisfied that it was impulsive. There was no evidence of any guilt. There's no evidence aside from that to prove that you knew it was stolen or you suspected. They have to find you not guilty. But you don't want to do that. Instead, you just want to muddy the waters with stuff that has no relevance. This is a simple case. That's why the judge is completely baffled. Because the judge knows it's a simple case. The judge knows that you're not going to go to court, to prison if you're found guilty. But he's not saying, well, I'm not saying you're going to be found guilty. I'm trying to tell you that you have a good chance of being found not guilty if you work with us. But you refuse to work with us.
Sam, you told me that it looks very sketchy. You said I've got a 25% chance of winning.
It looks very sketchy because we need to explain why you put it under the floor.
No, this was when I went to.
Let me finish. You see a psychologist who said, yes, he has a serious case of ADHD, which would cause him to react in a way that others wouldn't. And so it's no evidence of a guilty mind. It's just his reaction to a stressful situation. That is an explanation, Toby. We have an explanation. Okay. I said if we don't have an explanation, we have a problem. If we do have an explanation, which we're trying to assist you with, but you refuse to comply with any help that we're trying to offer, and I'm telling you that without that, you cannot win this. With it, you can.
Okay.
I've told you this repeatedly, but you don't want to listen. I'm telling you, as a fact, just as Sweeney has, if you do not have an explanation for that laptop being under the floorboards, you will be found guilty. If you meet a psychologist and he explains that you have ADHD and you react in a certain way which causes you to do things in impulse or on impulse, then that goes before a jury and they've got no reason to suspect that you knew or suspected that those items were stolen. It's one laptop.
Sam, I know.
There's no way that you could have known that it was stolen. So it's just a coincidence that same laptop was the one that was under the floorboards. But that was not because you knew or suspected. It was just your reaction to a stressful situation. Full stop.
I know that, Sam. I know the case. I know exactly what's what it's about.
And that's what I'm baffled by when you go on, you talk about all this other stuff, and what I'm trying to tell you is that this case is simply about that laptop being under the floorboard. That is it. If we can explain that, then the prosecution's case is not as strong as it's made out. That is it. You keep asking me all this stuff that has no relevance to anything.
I'll just
be honest with you, it just annoys me because I'm trying to help you, and you just annoy me because it's like, I don't care, Toby. I don't care. The court doesn't care about all this stuff you're waffling on about. They don't care. Nobody cares but you and the people that you talk about with your crown and whatever. Nobody cares. It's a very simple matter. Very simple, but you're complicating it.
Okay, have a look. Just do me a favour and just look up Cole Grant. Caul.
Yeah, but I don't need to look him up, Toby. This is what I'm trying to.
Well, no, but this is.
How was looking up Cole Grant? Explain it to me. How was looking up Cole Grant going to assist when you were asked how come the floorboard, the laptop was under the floorboards?
I'll just.
How was that going to assist?
Sam, Sam, I'll just say, if you got a bit of
questions to me, and I put a simple question to you saying that I'm representing you in a matter of handling stolen goods. That is it.
And possession of firearms.
I'm asking, yes, which we haven't even discussed because we spent so much time dealing with the other one. Nobody cares about the possession of the firearm because it's stupid case in itself.
Right.
But if they get a conviction with handling stolen goods, they probably won't even give a shit about the possession of firearm.
Yeah, but okay.
Ultimately, it's all statistics. Ultimately, Toby, it's all statistics.
Yeah, that's right. Yeah, I mean, you've told me that I'm not going to. That you told me before that I could be looking at a prison sentence for them, but now you're telling me that I'm not going to go.
I'm saying to you, no. I'm saying to you, and I've said to you, and Sweeney has told you that, of course, there is a possibility.
Yeah.
We do not believe that you will get that.
Yeah.
We have told you that.
Yeah. Okay.
I've said, just like anybody, when they are charged with anything, unless it's really, really minor, there's always the risk of a custodial sentence. Nobody can tell you that you will certainly not get a custodial sentence. You know why? Because we don't mind read. And in fact, if we had said that to somebody and they did, then how would that make us look if we said, well, you're almost certainly not? Nobody can say that you're certainly not.
That's right.
Because a sentence, it's a potential charge that has a possibility of imprisonment. I'm telling you that I do not believe 99% certain that you will, but there's still the 1% that you could. Now, given all the crap that's going on with this, I can tell you what my view is, that you go and you represent yourself and you piss the judge off, then you're increasing your possibility of getting a custodial sentence.
Right.
That much I will tell you.
Yeah. Okay.
If you worked with us, then I tell you now, 99.9% certain that even if you were found guilty, you would not get a custodial sentence. You might get a community order, but you would absolutely certainly not get a custodial sentence because there's no reason to. But if you go to court and you start talking about coerce and crown that, all you're going to do is piss the judge off. Okay? You will be in contempt, and he probably will put you in custody. Won't be for long, but you probably will go in custody just because you pissed him off, because you've gone on about stuff that is of no relevance, and you're not trying to help yourself.
But is there impartial, isn't it?
Sorry?
Is there impartial, isn't it? It's the jury to decide. Is there the impartial for both parts?
The jury don't decide what sentence you get.
No, but the judge. Yeah, but the judge impartial.
The jury decide whether you're guilty or not guilty.
Yeah, but the judge is impartial to the whole case, isn't he?
He's impartial, but if you keep going on in front of the jury about stuff that has no relevance, and he keeps telling you, and then you want to keep saying, "God, I want an answer to that," you will be held in contempt.
Yeah, I understand the contempt. I understand.
That's what I'm trying to tell you.
Yeah.
If you keep, like the conversations you've had with me, if you do that in court, he won't be having these conversations I'm having with you. He will warn you that you will be held in contempt. And then you will keep saying it, and you'll say, "But I only want an answer to it." And he will only tell you a couple of times, then you will be held in contempt. Simple as that.
Okay.
It's not a forum for you. It's not a forum for you to start, discussing things or your views on things that are of no relevance. That is not the forum for it, and he will make that completely clear to you.
Okay.
You will get warned maybe once. You'll be lucky to be warned
Okay.
Because you won't be happy if you do represent yourself. Judge won't be happy with that anyway, and so you will have a very short leash.
Okay. Have I got the same judge down there then that's dealing with this?
I'm pretty sure, yeah, Statman. Yeah.
Oh right. Okay. Excellent. I might pop down and go and see him in action next week to go and see how he operates.
I wouldn't advise that. You're not supposed to go down there.
Well, I can go and sit in the public gallery, can't I?
Well, technically you can. Just remember that there is. I did tell you about what was said.
What was that?
When I'm not going through it again. We've already been through that. I've already told you what Judge Statman said in relation to.
I've got it here. I've got it in your letter you wrote to me. His Honour Judge Statman firstly warn you, in your absence and through Mr. Sweeney, that if you attended the court office, attempted to contact the court office by email or telephone, or sent a correspondence to the court, other than through this firm, you will be held in contempt.
Yep.
But contempt of court and held in contempt. I mean, they can't be held in contempt for going down to in the public gallery to watch Genevieve's court cases, surely.
I don't know. Potentially, it's open to interpretation.
Oh, all right. Well,
the court are basically saying that you're not to go there. It's open to interpretation. Now,
it's a public building. It's my building. We pay for it.
I know that. You know what? You can do what we've already been through that. I told you got that in writing, then you can interpret it how you want.
Okay. All right, Sam. Okay. Well, I won't take up any more of your time. I'll obviously see you. Well, it won't be you, will it? Be Steve Sweeney on the 8th.
Yep.
Okay. All right then, Sam.
Bye.
Cheers, Sam. Bye bye. Oh, that's interesting. It seemed to go on a little bit. I don't know what your feelings were about that. It seems to be as soon as I sort of mentioned that I want to sort of sack him or actually represent myself, he seems to be very anti me representing myself. Now, I don't know why that is. I mean, I don't know. I've always followed the system. I've been involved in the system. I've been to court many times, many times, and I've used this representative, not him personally, but his firm is a partner in the firm now, on many occasions, and been very successful, and I've had great confidence with them. But obviously, it's only because of learning what I've been learning. Now I see exactly how corrupt the court system is, and especially being through it first hand so many times on the legalese side, so to speak. It's very difficult. I mean, a sort of transition period, like a changeover, because I know what he's saying, that they're trying to represent me and they're trying to do what's right for me, but then I also know they're a bunch of lying cunts, and they've got their first loyalty is to the courts. Their duties, liabilities, responsibilities lie with the courts. They don't lie with me. This is who that they're. That sounds a bit official. 2 seconds. I'm just going to go and grab that. Hello, mate. Cheers, mate. Thanks a lot. It's the postman bringing some more bills and some return to sender letters. No, it's my water filters. Where was I? Yeah, so it's sort of a bit of a stuck between a rock and a hard place, because I understand that they want to try and help me, but also know that they're also going to probably try and fuck me. And obviously I think that was quite apparent when obviously I said to him that I want to represent myself. Some of the points I've raised with him is in relation to the legality of the actual arrest and the unlawfulness of them actually entering my property in the first place. Kicking my door in at 9:30 at night, 8 of them come stealing from my house without a warrant signed by the courts. Was unlawful. I never invited them in. In fact, I asked to see a signed warrant, and they forced me out of the way. So from the start, from right from the beginning, it was pretty unlawful on their behalf.